Hi everyone, welcome to Title 14 or the Dissolution of the Corporation. The sections here are relatively self-explanatory. I just want to point out that the modes of dissolution are voluntary and involuntary, as can be seen in sections 134 and 130. Let's see, 138. So in particular, no, if you will look at Attorney Lacos notes, the types of voluntary dissolution are when either creditors are affected or when they are not affected. Number three, by the shortening of the corporate term. This is because the corporation would need to amend the articles. This is different from the expiration of the term, and by merger or consolidation, whereas involuntary modes would be, as I've mentioned, the expiration of the term, the failure to organize within 5 years, legislative dissolution, and dissolution by SEC on grounds stated under different laws. No? So, um, take note that it is possible for a shortening of the corporate term to be both voluntary and involuntary. When does this happen? Usually when corporations amend the articles to have the corporate term end immediately. And it becomes voluntary because there is a need to amend, but it becomes involuntary in a sense that upon the approval of the SEC, corporate term has already ceased. Corporate personality has already ceased. So what are the grounds for automatic dissolution by operation of law? Um, I have already mentioned that. No, I'm just reading Attorney Lacos notes. There are times when there is an automatic dissolution, and there are times where there is a need for a court order. And these are instances where one, a corporation is de facto. So this is through a quo warranto proceeding of the initiated by the government. Two, violation of the rulings of the SEC. There's a need for court order because any violation of SEC rules and regulations normally requires a hearing first. They cannot automatically just cut the life of a corporation ipso facto because that would be unfair and it would be violative of the corporation's due process. Number three would be failure to submit an annual report. The same way because there is a need for the corporation to be heard. And number four, continuous operation of at least 5 years. And for the same reason, because there needs to be proof. The corporation can prove that they were actually in operation for that period that the SEC claims that the corporation wasn't. Let me just quickly go over some steps. For example, under Section 134, for voluntary dissolution where there are no creditors, one, at least 20 days prior to the meeting, notice shall be given, and there should be the content stated therein as to what should be placed in the notice. Two, the notice shall be published once prior to the date of the meeting. Three, a verified request shall be filed with the SEC stating here letters A to E. Number four, the corporation shall submit the following things to the commission SEC, which are stated under numbers 1 to 3. And then number 5, step 5, within 15 days from the receipt and absence of any withdrawal within the period, the SEC shall approve the request. So if you look at it, it looks like the SEC does not have any option but to approve. The only thing that the SEC will do is verify if all the steps have been taken. So just take note at the last paragraph that a favorable recommendation is required for the types of corporations stated therein. When it comes to a voluntary dissolution under Section 135, where the creditors are affected, one would be a verified petition there, signed by majority of the corporation's board and verified by the following people. And then the contents therein are stated also in the provision. If the petition is sufficient in form and substance, meaning it follows the one stated above in the paragraph here, then it shall order a certain period to file objections by creditors who may or may not have been notified, because it's possible that there are some who will bring forth a claim. So there is also a requirement of publication. However, the publication here would be for 3 weeks. Plus, aside from publication, there is also posting in a public place. And then after that, the SEC shall have a hearing after 5 days, after the period to file objections. And if there are no objections, then the SEC will render a judgment ordering the dissolution. So the dissolution, again, much like involuntary dissolution under Section 134, it shall take effect upon the issuance of a certificate of dissolution. And then there is Section 136, that's relatively self-explanatory. And what else? Section 137 and 138 are likewise self-explanatory. So for in the interest of time, I will not anymore discuss them. Let me just clarify. When you talk about dissolution, you are talking about the cessation of a corporate life. Whereas in a liquidation, we are talking about settling the affairs, winding up. So these are payment of debts, collection of the receivables rather. Yeah, so that's the difference. And let's see. When a corporation is dissolved, the corporation ceases to act as a body corporate, but only insofar as continuing the business is concerned. It continues to act as a body for purposes of liquidation or winding up. Now, let's see. Upon the dissolution and winding up of a corporation, the stockholders can only receive the assets if all debts have been paid. So if there are unknown creditors, then a portion of the assets, or if the creditors cannot be found, then a portion of the assets in payment of their debts shall be escheated to the government. Any remaining will be given to the stockholders. Upon the receipt of the stockholders' shareholdings, they have the option to continue into a new corporation. But that has nothing to do with the old. Kumbaga, there is a complete severance of ties between the dissolved corporation and a new corporation should the stockholders decide to form a new one. If there is a revocation of certificate of incorporation, and this leads to the dissolution of a corporation. If you remember Section 17, if the corporation fails to comply with the cease and desist order issued by the SEC for the use of a name that violates the provisions, then it can be revoked. So just take note of that. That's also another ground for dissolution. There's another one. The SEC can revoke the certificate of incorporation if, following Section 178, the corporation without justifiable reasons refuses or obstructs the exercise of the SEC's visitorial powers. So what about withdrawal of the petition? Yan. Under Section 137. The withdrawal of a request or petition for dissolution is different from a petition for revival. A petition for revival presupposes that the corporation has already ceased completely. So these are actually covered by SEC memorandum. An SEC memorandum I will not mention anymore, so you won't need to memorize it. These are just covering instances like where the corporation whose term has already expired, where the expired corporation whose certificate of registration has been revoked for non-filing of reports, provided that it shall file a proper petition to lift its revoked status, an expired corporation whose certificate of registration has been suspended, and one an expired corporation, can you notice there's a qualification expired corporation, because it has already been its corporate personality has already ceased now. So an expired corporation whose corporate name has been validly reissued, and is currently being used by an existing corporation duly registered with the SEC. So what is important in this case is that the expired corporation shall change its name within 30 days from the revival of its corporate existence. So you'd be thinking, when are these instances of revival? If you remember, under the first few sections of the Corporation Code, because of the provision where a corporation now has perpetual life, then it can actually revive in order to take advantage of this new provision. Continuing to liquidation, as I have already defined earlier, it is the process of winding up or settling the affairs. So Section 139, if you will see, there is no need for an approval by the SEC. Why? Because this is an internal matter falling within the powers of the directors, trustees, or if there is an appointed receiver, no? Or if there is an appointed liquidation trustee. Now, the SEC is not, liquidation is not under the jurisdiction of the SEC. However, you will notice that the SEC has jurisdiction to order dissolution. So there's a difference. Let's see what you need to know. The normal method is that the directors or the executive officers take charge, mainly because they are the ones who run the business, so they would be the persons in the best position to order a liquidation. But it is also possible to have receivers appointed by the SEC. Liquidation can also be initiated which would require the intervention of the court, and this is under the Financial Rehabilitation and Insolvency Act. Why? If from the word financial rehabilitation and insolvency, initially the corporation would want to rehabilitate. Rehabilitate is where it will try to change the structure of payments in order to meet its debts in hand. So it's sort of a compromise. Now, in instances where a rehabilitation is not possible, or it is not anymore economically feasible to continue business operations, then the court can order the the liquidation to proceed. So what is part of settling the affairs? The collection of all debts, settlement of all claims, and the payment of the corporation's debts. So the corporation technically has an extended authority, as I mentioned. It still continues as a body corporate for 3 years, but only for purposes of winding up. Therefore, it cannot continue the business for which it was established. Take note that although it says the corporation cannot continue its business, it does not mean that it can just abandon its obligations under existing contracts. So really, you're just winding up, you're finishing up. That's what you can do for the next 3 years. Now, the 3-year period for winding up only relates to the powers of the corporation, meaning the directors and the the trustees, directors or trustees. However, if the liquidation is entrusted to a trustee, then the 3-year period does not apply to them. Because if you will notice, the 3-year period is given to the corporation to either to liquidate or to convey all its property to trustees. Yan. So that is what the 3-year period is for. Just note that what if after 3 years, the corporation's pieces of property are still with the directors, in that case, the directors will be considered trustees by legal implication, and they are acting as trustees and not on behalf of the corporation per se. So, for example, lawyers who are handling cases for the corporation can also be considered trustees of the assets after the 3-year period. And these are in cases where there are no trustees appointed, ha. Nothing bars the recovery of debts of the corporation after the 3-year liquidation period. And the claim of the creditors follows the assets of the corporation. So, let's see. The rights of the stockholder. The termination of the corporation's life does not extinguish or diminish its rights. And what is given to the stockholders are what we call liquidating dividends. So again, I will repeat, rehabilitation is different from dissolution or winding up. A rehabilitation happens when the corporation is in distress, but the directors or trustees believe that they can still continue operation. So it refers to the restoration to a condition of successful operation. Because of this definition, rehabilitation and liquidation cannot be undertaken at the same time. So I will skip the portions on rehabilitations. I don't think you need to know that. As I've already mentioned, liquidation can occur during rehabilitation proceedings, and upon the when liquidation is to be performed, meaning we are to already pay the debts, please note that the rules on concurrence and preference of credits under the new civil code will be observed. So usually this means that creditors with mortgages will be preferred because rather than, so this would mean that secured creditors will be preferred over unsecured creditors. Secured creditors referring to those who hold pieces of property of the corporation as security for its debts. That's one. Or for example, a creditor who extended a loan to the corporation with interest is a preferred creditor over someone who did not charge interest, although that is unlikely. But I'm just trying to tell you what is the normal method of what is concurrence and preference of credit. So if you'd want, during your free time, you can just check it out on the new civil code. Yeah. So that ends Title 14.